So now Unit 5, the federal system. In this unit, distribution of financial powers, need, principles underlying distribution of tax revenues, distribution of legislative power, interstate relation, and emergency provisions. Introduction. Before independence, most leaders needed divide the powers between provinces and the central government. There was also awareness that Indian society had regional diversity and linguistic diversity. This diversity needed recognition. People of different regions and languages had to share power, and in each region, people of that region should govern themselves. This was only logical if we wanted a democratic government. The only question was what should be the extent powers to be enjoyed by the regional governments. Once the decision to partition India was taken, the Constituent Assembly decided to frame a government that would be based on the principles of unity and cooperation with the center and the state and separate powers to the states. The most important feature of the federal system adopted by the state Indian Constitution is the principle that the relations between the states and the center would be based on cooperation. Thus, while recognizing diversity, the Constitution emphasized unity. Constitution of India does not even mention the word federation. This is how the Constitution describes India. Article 1. India, that is Bharat, shall be a union of states. The state and the territories thereof shall be as specified in the first schedule. Two sets of governments created by the Indian Constitution, one for state and another one for central. If there is any dispute about which powers come under the control of the Union and which under the states, this can be resolved by the judiciary on the basis of the constitutional provisions. This is the structure of the Constitution of India. Division of powers. The division of power is a concept of theoretically enumerated by John Locke. In federalism, there should be a clear division of powers so that the units and the center are required to enact and legislate within their sphere of activity, and none violates its limits and tries to encroach upon the functions of others. In a federal system, different units of governance enter into an agreement to support each other on common interest and respect each other's autonomy in deciding about their interest. Division of powers. The seventh schedule part 9 contains three legislative lists which mentions subjects for legislation by the union government, state governments, and jointly by the union government and state governments. List 1 union list, list 2 state list, list 3 concurrent list. The particular arrangement was necessities by then prevailing conditions in the country. The Hindus favoring a strong center while the Muslims are favoring strong provinces. Next, the basis provisions regarding the distribution of powers between the central and provincial governments in the Indian Constitution are present in Part 9, Article 246 of the Constitution. This part is divided into two chapters, legislative relations and administrative relations. Indian Constitution has followed a system in which there are two lists of legislative powers, one for the center and another one for the state. The Constituent Assembly of India followed the system of division of as was envisioned by the Government of India Act 1935 regarding the provisions about relations of power in India. The union list consists of 97 items. It is the longest of three lists. It includes longest three list, and state list consists of 66 items. Some of the most important of these items are follows: public order, police, administration of justice, prisons, local government, public health and sanitation. And these are all the state list. And concurrently, these are items with respect to which uniformity of legislation throughout the union is desirable but not essential. As such, they are placed under the jurisdiction of both the union and the state. The list includes the following: marriage and divorce, contracts, civil procedures, contempt of court, electricity, newspapers, stamp duties, etc. Residuary powers of legislation Residuary power or the powers to legislate on the issues which are not mentioned in the three lists mentioned above. In India, the residuary power are vested in the Union, although the state in India have the exclusive power of legislation. Next, Article 249 of Indian Constitution provides that if the Rajya Sabha has declared by a resolution supported by not less than two-thirds of members present and voting that it was necessary or expedient in the national interest division of powers that the Parliament should make laws with respect to any matter enumerated in the state list specified by the resolution. Next, Article 252, Parliament also becomes entitled for legislating two or more states by their consent. 253, Parliament has the power of legislating any law for the whole or any part of the India. And Article 356 stipulates that if the President is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution. Sarkaria Commission, that is interstate relation. In June 1983, the central government appointed Sarkarian Commission under the chairmanship of Justice R.S. Sarkaria to review the scope and working of constitutional provisions on center-state relations. Next, but it did not support centralization of power in the Union government. The Commission also recommended establishment of a permanent interstate council under Article 263. Next, in April 2007, the UPA, United Progressive Alliance government appointed Punchi Commission under the chairmanship of Justice M.M. Punchi. Its purpose to review the roles and responsibilities of various levels of governance, center-state relation, panchayat raj institutions and local bodies and their interrelations, administrative and financial distribution of powers. The Constitution emphasized that there should be administrative cooperation between the Union and the states. Article 292, financial relation between the unions and state governments for raising enough funds. Article 292, which authorized the Union government to borrow upon the security of the consolidated funds of India within the limits which may be fixed by parliamentary law from time to time. Duties levied by the union but collected and appropriated by the state. Such stamp duties and such duties of excise on medicinal and toilet construction collected by the union government. Taxes levied by collected. Taxes on the sales or purchase of goods and taxes on the consignment of goods shall be levied and collected by the government of India. Next, notwithstanding anything in Articles 269 and 270. There shall be charged on the consolidated fund of India in each year of grant in aid of the revenues of the state of the Assam, Bihar, Odisha and West Bengal in lieu of assignment of any share of the net proceeds in each year of export duty on jute and jute products to those states. Such sums as may be prescribed. Savings. Any taxes, duties, cesses or fees which immediately before the commencement of the Constitution were being lawfully levied by the government of any state or by any municipality. Finance Commission, the President shall within 2 years from the commencement of this Constitution and thereafter exemption from taxes on electricity consumed in construction, maintenance or operation of any railway by the government of India or a railway company operating that railway or sold to the government or any such railway company for consumption in the construction, maintenance or operation of any railway. Next, state and union taxation. Next, emergency provisions. Emergency is a political system and denotes a situation in which the chief executive imposes restrictions on the right to freedom of people. In India, such restrictions are imposed according to certain provisions enshrined in the Constitution, generally known as emergency provisions. Historical background. Constitution of India has emergency provisions which may have been borrowed from Constitution of Weimar, that is Germany, and Government of India Act 1935. Indian Constitution followed Government of India Act 1935, which embodied emergency provisions in Section 45 for the center and in Section 93 for the provinces. Types of emergency. As you have read, emergency is India in declared by the President. National emergency, state emergency, financial emergency. First, national emergency is war, external aggression, and already we know that internal disturbance, armed rebellion, like that. Every proclamation of such emergency is required to be laid before each house of parliament. Thank you.